All right, good morning. Let's see. Is Mr. Jameson present?
Yes, Your Honor.
I'm here as well, Your Honor.
All
Jordan
right.
Nation, his attorney.
All right. Okay, so this is file 215171SD, People versus Jack Jameson. And Ms. Ashion is here on behalf of the defendant. And this is the date set for sentencing on the defendant's conviction of operating while intoxicated. So, Ms. Ashion, have you had an opportunity to go over the pre-sentence report and the assessment with your client, and are they accurate and complete?
Yes, Your Honor.
All right, then. What would you like to say on behalf of Mr. Jameson?
Thank you. Mr. Jameson has accomplished so much in his life. He's only 27 years old, and he is a young professional who's extremely remorseful and disappointed in himself that he's in this position he is in today. He graduated from NMC College with a bachelor's in marine technology, an associate's in underwater electronics and remotely operated vehicles, and an associate's of land surveying. Took him 7 years full time to complete this, all the while working full time and supporting himself. He currently works at Gertie Fraser, and I provided Your Honor with a copy of a letter written by his boss expressing their appreciation of him as an employee and the value they show in him. He's been there for 3 years. He works as a crew chief field technician, which requires him to drive daily all throughout the state to map and survey properties for things such as bridge repair, hydraulic surveys for environmental impact studies, and marine engineering. He is very involved in the community, involved in volunteers, in Adopt a Highway Cleanup, Michigan Society of Professional Surveyors, Marine Technology Society, and Hydrographic Surveyors of America. As I indicated, he is remorseful. He has completed all terms of his probation. Before it was required of him of probation, he proactively got an alcohol assessment. I believe Your Honor has a report of that as well. The report indicates that he was very forthright and candid in all of his answers. He has no history of illegal drug use or prescription drug use, no history in his family of either as well. Most notably, the report indicates that he does not have a substance dependency disorder. It was also a recommendation that he attend the highway safety class, which he has already proactively signed up for and will be attending on July 24th. He's disappointed and embarrassed himself that he spent so long on his career and accomplished so much and is now in this position. He has great family and friends support. And so we would ask that you consider all of this in a determination of your sentencing. I believe he would also like to speak on his own behalf.
Okay. All right. So, Mr. Jameson, is there anything you'd like to add?
Yes, Your Honor. Yeah, I know the decision to drive that night. I'm very remorseful about it. I know it was a mistake, and I'm really disappointed in myself for choosing to drive. I've worked really hard the last few years getting myself into a position where I can have a career here in my hometown where I grew up, and I found it, and I've just graduated and finally getting to school, and I'm ready to get going. And this is just putting a hold on me right now, and I'm just really disappointed in my decision there.
All right, thank you. This is, again, sentencing on defendant's conviction of operating while intoxicated. The facts are that the defendant was at the bowling alley, had too much to drink. Oh, Ms. Ashion, I did have a question. Did you ever get a blood test result?
I have not, Your Honor, and I believe in the pre-sentencing report, it also indicated that probation did not, and they had asked the prosecutors for it, and they had not received it either.
Okay, all right, well, thank you. The defendant admitted that he had consumed too much alcohol to be driving, although we don't know what the exact result of the test was. And according to the officer, at least, the defendant appeared to be trying to get into his home before the officer could catch up to him. So anyhow, the defendant was taken to the hospital for a blood draw. The defendant was placed on bond. There was one missed PBT and a dilute urine screen. But otherwise, defendant was successful completing those bond conditions. The defendant does seem to accept responsibility for his actions and seems remorseful for those. With regard to the substance assessment, there are a couple of limitations with this assessment. First of all, we don't know what the blood alcohol test was, which I think would have to be significant to any analysis of this. The other thing is that the defendant reported having one MIP at the age of 17, when in fact he has had 2 MIPs. Now, they were close in time. They were the same year, but the first one resulted in a loss of deferral and unsuccessful termination of the probation. The second was successful probation on the MIP second. But this is the defendant's third involvement with the criminal law because of alcohol. So to some extent, I see the assessment as somewhat limited by the defendant's lack of candor, as well as the fact that the assessor did not have a blood alcohol level. The defendant comes to the court at the age of 27 with, I would agree, an impressive background here. He has a bachelor's degree, good job working for Gordy Frazier. Happy to be working in his hometown. He's a volunteer. He's obviously well liked where he works, and probably works too many hours. Says 50 to 70 hours a week. But I want to tell you, Mr. Jameson, you can throw all of that away by not dealing appropriately with an alcohol problem. And I've seen it too many times. And it doesn't matter how impressive you are on paper. At some point, these things catch up to you. And for whatever reason, it's very unusual to have someone with 3 involvements with the criminal law system. It's not unusual for me because I'm a judge and this is what I deal with every day. But if you look at the population of individuals in our community, it's a very small percentage that would have this many troubles with alcohol. And so you need to take this very seriously because you've got a bright future, and you can throw that all away if you don't take care of this. And one thing is you've got to be honest with anyone that's trying to help you. So with withholding information from the assessor, well, that's not helpful anyway. So they can't help you if they don't know what the problem is. So anyway, the recommendation is for 90 days of probation, but I think that 180 days is more appropriate, given this is the third involvement with the criminal justice system for this defendant. The court will review the probationary term at the 3-month mark, or 90 days if requested by the defendant, and if there are no violations and all the conditions of probation have been met. The fine is going to be $200. There's costs $400. Crime Victims Fund $75. Judicial system fee is $50. $125 to the arresting agency, and the blood draw is a $22.30 charge for the prosecutor's office. The purpose of the probation is rehabilitative in nature, and that is we don't want to see Mr. Jamison back here on another criminal offense. Now, hopefully these conditions will prevent that and keep our community safer. So during the term of probation, you're not to use or possess any alcohol, no mind or mood altering substances, including marijuana, no non-prescribed medications, or obviously no illegal drugs. You're not to reside where those substances are present, and you're not to enter any bars or casinos. I'm not going to include restaurants that are primarily for the purpose of serving food, not alcohol. But bars are off limits, restaurants are not, and I'm sure you know the difference. You're not to behave in a violent, threatening, intimidating, or harassing manner toward anyone, and be respectful of all court employees and care providers. Consistent with the substance use evaluation, you're to attend, cooperate, and complete and pay the fee for the Alcohol Highway Safety Education and Victim Impact Panel. You're to complete a new assessment through our Catholic Human Services or Mr. Zoutendam, and disclose all of the information about your prior record, including the unsuccessful first probation for MIP, and the blood alcohol result once that is obtained by the prosecutor, which I can't imagine it hasn't been obtained by now, and follow any additional recommendations that Mr. Zoutendam or Catholic Human Services has for you. Let's see, you're also to take and pass daily preliminary breath tests and submit to discretionary testing for both drugs and alcohol at the court request of either the court or law enforcement. The jail time is 4 days, and that's credit for time served. Let's see, other than that, you need to notify the probation office of any contact with law enforcement. You're also to contact the probation office, and there's a phone number on the pre-sentence report for that, sometime between 1 and 4 p.m. this afternoon. They'll answer any questions you have about the probation terms and go over those in more detail with you. Are there anything else for you, Ms. Ashion?
No, Your Honor. Thank you.
Okay, thank you. Good luck to you, Mr. Jamison. I do hope that you're successful on this probation, and I can sign a successful discharge from probation at the end of this, okay? All right. I'm serious about the alcohol problem, though. I mean, 3 times, this looks like a problem to me, and you need to take it seriously, okay?
I will, sir.
All right. Thank you. All right. So let's go on to Austin Phillips, and that is file 215283FY1. And Mr. Williams is here on behalf of Mr. Phillips. And let's see, Ms. Wilson is here for the prosecutor's office. And I do see we have the victim in this case, Also present, Ms. Godziak, I hope I pronounced that correctly. And let's see, and I have reviewed the pre-sentence report, the victim impact statement, the assessment, and the letter I received just this morning from Ms. Godziak, as well as another letter from Dr. Cavadella, a psychiatrist. So, Mr. Williams, have you had an opportunity to review those with your client, and is the report accurate and complete?
Yes, I have had an opportunity to review that with Mr. Phillips, and the report itself appears to be accurate and complete.
Okay, so then what would you like to say on behalf of your client?
Well, there's a couple of things I'd like to say. One, the victim in this case has contacted me several times, and I've instructed her that there's a victim's rights coordinator that she could talk to. And in fact, she sent me her statement for review, and I told her I didn't want to influence whatever she had to say. But I think what's most concerning is that nobody ever told her she had the right to speak here at sentencing today. I was the one to tell her that. She was surprised to know that. In fact, I told her that this morning because of her persistent contacting me and concerns about everything going on in this case. So I don't know why that didn't occur, but it's certainly not proper. So I want to make a record of that. Two, the rest of it I can address in elocution, but I just want the court to be aware of that. So.
Okay, well, so what would you like to say then on behalf of your client?
Well, a lot of things. You know, I'm looking at this, you know, this PSI, and I'm not gonna put any weight into a juvenile adjudication at all. It's listed, but it's, you know, it's as a previous record, but it's an adjudication. It's not a conviction. Two, I'm really concerned about the way the report's written. We have a young man who has mental health problems and substance abuse problems, and none of that is addressed in the PSI at all, which is the big elephant in the room. The victim in this case, his grandmother, wants him to come back home to live with her. She takes care of him. He has mental health issues and takes medication for it. The psychiatrist wrote a letter explaining that he's following the treatment plan and he's actually doing really well, and he is doing really well. And look at the amount of time he's been on bond without any incident whatsoever. So we're looking at his prior record. He has 2 domestic assaults. This was a third. It started as a felony. Yeah, that sounds real serious on paper, but let's really break it down for what it really is. You have a young man with mental health problems who's never been properly medicated and didn't have the proper professionals in his life or the infrastructure to fix that problem, because that's what the problem is. And that's all the problem is. He's not some monster out there hurting, harming people. He's a person that has anger issues and mental health issues that hasn't had the proper treatment. And currently he has the proper treatment, and everyone around him, including his grandmother who wants to talk to the court today, will confirm that. So this is an unhealthy recommendation that I see in this PSI, and it's disappointing to say the least. Misdemeanors are meant to be rehabilitative. And that's the whole purpose of the district court, is to rehabilitate people so we keep people in our community safe and healthy, and we don't have things grow out of control to turn into bigger problems in the community. And right now we have the infrastructure in place. We have a young man taking his medications, a young man working full time and doing really well. And to disrupt that and put him in jail as a purely punitive measure doesn't do anyone any good at all. It doesn't deter the next mentally ill person that has a substance abuse problem to not commit a crime. It simply does nothing but deter this person's progress and all the family and support that is surrounding him as well. So I'm asking the court to make this a rehabilitative sentence and not place him in jail. Obviously, the court can place him in jail up to a year if the court deems it necessary. There's lots of other things the court can do today that don't include jail that would be healthy and would be consistent with the actual professional who addressed the court on what the concerns and issues are. So I would ask the court to consider all of that when imposing a sentence today. In addition to that, I would ask the court to listen to his grandmother and lift the no contact order. So I would leave it at that for now, Your Honor.
Okay. Mr. Phillips, is there anything that you'd like to say on before I sentence you?
Yes. I'd like to basically concur with what he was saying. I do admit that I have mental health issues, substance abuse problems, history of anger, and I haven't been fully responsible for taking accountability for any of that in my past. And this last incident that I've been involved with was a real wake-up call for myself. I was dealing with a lot of mental issues. I wasn't being fully honest with my psychiatrist about my drinking or anything, anger problems I was having. I've informed her of that, and basically we're kind of restarting. I've been seeing her since I was 18, and I've just kind of been in a restart session, really reforming myself and becoming a new person, getting on this new medication that's changing me, not touching alcohol. And I am very sorry for my actions and remorseful.
All right. Thank you, Mr. Phillips. Ms. Wilson, is there anything for the people? And I will get to Ms. Godesack before we're done here. So, but anything for you, Ms. Wilson?
The people would just ask that you follow the recommendations in the PSI. Thank you.
All right. So, Ms. Godesack, you do have a right to speak if you would like to this morning. And so is there something more that you would like to say? I have reviewed the letter that was received. Well, I got it this morning. I don't know when it was actually received by the court. I see some kind of fax number 627, but and then I've also reviewed your victim impact statement that was submitted to the prosecutor's office. And, but anyway, I would like to hear from you.
Your Honor, I have removed all alcohol from the house, and there will not be any alcohol or anything of temptation here in the house. I would very, very much like Austin to move back into my house with me. He's been a support for me. He's taken care of me, and I need him back in my life.
All right, and you're not afraid of him in any way?
Gosh, no, Your Honor, not at all.
Now, I know that he's, it sounds like doing better with the medication that's been prescribed by his psychiatrist. And is there a history of him going off those, or?
I have talked to Dr. Cavadella, and the medication that he is on now, he's never been on before, and he needed to be on, but he wasn't taking the medication, and he is now. I haven't had any contact with him, Your Honor, so I don't exactly know, you know, how he's doing on the new med. But Dr. Cavadella has told me that he is following all her recommendations now.
Okay, because if I lift the no contact today. My concern is that, you know, maybe he stops taking these medications and maybe there's some safety issue with you because of that. And that's why I asked if there's a history of maybe starting and going off medications in the past. Has that been your experience or not?
No, Your Honor. Austin has been on Vyvanse for like 8 or 9 years, and he's been taking the Vyvanse. But he needed something for anxiety and depression, and he's on that now. No, he's continued with the Vyvanse for either 8 or 9 years.
The Vyvanse, isn't that for ADHD?
Yes.
Okay. All right. Okay, well, thank you. I sure appreciate your comments. Was that it? Or you're finished?
Yes, Your Honor.
All right, thank you. All right, this is sentencing on the defendant's conviction of attempted flee and elude a police officer and domestic violence second offense. The facts are that Ms. Godazak has had the defendant prior to this living with her and her grandson, and asked him to quiet down. He was getting too loud playing video games, and at some point the defendant assaulted Ms. Godazak. It's reported he grabbed her hair or shirt and pulled her towards him. I know Ms. Godazak in her statements since then has said, well, maybe it was a mistake or something like that, but it was enough that she called the neighbors. She was frightened, and the report says that the defendant helped her end the call without further explanation. I don't know what that quite means, but the neighbors became concerned, called the police, and the defendant had apparently decided to get out of there and flee the scene. And he, at some point, developed the idea that he was going to drive to Florida and sped through a construction zone while being followed by the police. So he later changed his mind about Florida, I guess, when his girlfriend was involved in an accident. She must have called him, and when he showed up at the scene of that accident, the police caught up to him there. The defendant has been on bond since around the time of this offense, which was May 23rd. He's been on a Smart Start device with daily PBTs, has not had any issues there, and no misses on the monthly drug tests, and no violations. The substance use assessment indicates that the defendant does meet criteria for alcohol use disorder. It describes it as a moderate substance use disorder. There are basically 3 levels that they report out if there is a substance use disorder, either mild, moderate, or severe. So moderate is usually quite concerning to this court, okay? And apparently he was intoxicated at the time that this incident happened, and that's what he reported to Catholic Human Services for the evaluation. The defendant also comes to the court with a prior criminal history that is quite extensive. It involves 2 prior domestic violence offenses. And so that's why this is technically a domestic violence third offense, for which the defendant could be facing prison time. That is not what's happening, and I agree with the prosecutor's decision that this was better treated as a misdemeanor given the defendant's young age, and also that he does have several issues, including the alcohol problem, but also some mental health issues for which he was seeing a psychiatrist apparently before this. Ms. Godziak also reports that the defendant, from speaking to the psychiatrist, is taking some new medications for anxiety and depression, is doing much better according to the psychiatrist, and is asking for the no contact to be removed. To the defendant's credit, he is a high school graduate. He works at the kitchen, apparently was employed before that also, until this offense and his arrest, for which he served 4 days in jail. And so he is working pretty much full time now. And those are, oh, I should also note, with regard to the prior record, what's very concerning is that out of 1, 2, 3, 4, 5 probations, the defendant has been unsuccessful in all of those and has spent periods of up to 93 days in jail on at least 3 of those prior cases. And so that's concerning, because that tends to indicate that maybe he's not going to do so well if placed on probation. But I think what is different here is the last conviction was 2017. This is 4 years later, and there's a big difference between 21 and 25. And we also know that the defendant is on some additional medications. So this is what we're going to do. The probation term is going to be for the 2 years that's recommended. And I think there are several reasons for that. This is essentially 2 felony offenses that were pled down to misdemeanors, but the facts make out all of the elements of the greater offenses. And again, I agree with the prosecutor's decision to reduce this to misdemeanors, but at the same time, there needs to be some substantial period of monitoring the defendant in this case to try to achieve the rehabilitative goals that are desired, and basically to keep the defendant out of the criminal justice system. The fine is $200. There are costs of $800. Crime Victims Fund is $75. There's a $100 judicial system fee, I guess because of the 2 convictions, and then the arresting agency is $125. Well, I'm going to change the judicial system fee to $50. And the defendant will need to pay that off over the term of the probation. And in some ways, that's a good thing, because there's incentive for the defendant to work and get that paid off. And working is probably a good thing, because it's going to keep you out of trouble with alcohol or drugs, okay?
Yes.
During the term of the probation, obviously you're not to consume or possess alcohol, because that is a huge problem for you. You've got a substance use disorder involving alcohol, and just not helpful. You're also prohibited from you possessing or using any mind or mood altering substances, including marijuana. Now, I think there was some information the defendant has a medical marijuana card. Is that still true, Mr. Phillips?
Yes, Your Honor.
All right. I cannot prohibit you from using marijuana if you have a medical marijuana card, but have you discussed that with your psychiatrist?
Yes, Your Honor.
All right.
I will do whatever the court, sees fit.
I guess I would like to know that you have actually discussed that with your psychiatrist and that he thinks that that is appropriate given the other medications that you're taking. You haven't tested positive, as far as I know, for marijuana, but anyway, if you are considering using marijuana, I would like to get the additional information from your treating physician, the psychiatrist, that is appropriate given the medications that you're taking. And I'm sure Mr. Williams' antenna are going up right now given the TUI decision, but I'm not sure that TUI takes away every bit of discretion this court has, especially if I'm considering removing a no contact provision.
Well,
Go ahead, Mr. Williams.
For this particular case, I guess if it becomes necessary to make legal arguments, I will. I'm not going to today. I would like the court to recognize, though, that this resolution, although the prosecutor agreed to it, was my idea. This resolution was different than the original offer that was made in this case. And I appreciate the court recognizing that he's on a new medication, which is, I think, in my opinion, is the biggest factor in this case. That medication has changed him substantially. I mean, he's a real easy, pleasant person to communicate with because he's on that medication. So I'm just going to leave that alone for today, Your Honor. I don't see it being an issue, so I'm just going to leave it alone today.
All right. Okay. So the defendant is not to enter any bars or casinos or other establishments that serve alcohol by the glass unless it is for work purposes. And you're not to reside where those are present. Ms. Godesack has assured that that will be the case as long as you're living with her. You're not to use or possess any firearms or weapons or live where those are present. And you're not to behave in a manner that is violent, threatening, intimidating, or harassing toward anyone. Be respectful of court employees and care providers. Consistent with the evaluation, you're to attend 3 12-step program meetings per week with written verification each month. Obtain a 12-step sponsor within 90 days. And the purpose of that sponsor is to someone you can call and reach out to in times of temptation, I guess, to use, and of course to go through the 12-step program with you. And so that's very important to most people in recovery. You're to attend and complete the relapse prevention program with no unexcused absences. Follow all recommendations. You're also to attend the men's program with no unexcused absences, and you're to continue your treatment with your psychiatrist and follow all recommendations. You're to take and pass the daily AM preliminary breath tests, and your probation officer may adjust those testing requirements if you continue to do well. There will be discretionary testing as well for both drugs and alcohol. And let's see, you're not too, well, okay, with regard to the no contact order, Ms. Godesack has requested that that be removed. Now, I'm going to tell you, I am very reluctant to do that, given that this is a third offense domestic violence. And given that the defendant does have an alcohol problem, he's got a long criminal history. But I do believe that Ms. Godesack probably knows the defendant better than anyone else. I don't believe she is similar to most domestic violence victims that I deal with, where there's some financial or other interests that would conflict with their perspective on the situation. So I am going to lift the no contact order. With regard to the jail time, however, this is, again, 2 felony offenses that were reduced to misdemeanors. The defendant has a long prior criminal history. What is being recommended is community corrections. And I did speak with our community corrections supervisor, Ms. Shively, this morning. And she is on board with community corrections in this case. And what that means is that the defendant would be placed on supervision with a GPS tether, and he would have to complete a certain number of days in jail prior to being considered for community corrections. But she has, based on the circumstances I described to her, indicated that she would go along with the community corrections program.
Could I address that, Your Honor?
Yeah, go ahead, Mr. Williams.
I'm going to ask the court if the court wants to order GPS tether, which, I mean, he's been complacent on bond this entire time without any incident. Again, reminding everyone that he's now on a new medication that is working, and he hasn't been this entire time that he should have been. If you put him in jail today, I can guarantee you that he doesn't get his medications timely. And it's just going to create another big problem. You have a young man in front of you who the first time in his life is being medicated properly. And even just talking to him, his temperament is great. He's been complacent. He's complied with bond. He's not missed a test. He's done better than everyone else I've seen in court this morning. So putting him in jail is just going to be so counterproductive. He's not going to get his medications. It's going to interrupt the treatment. It's going to interrupt his time with his psychiatrist that he sees routinely, and it defeats all the work that's been accomplished. So I would ask the court, if the court wants to order him tethered, that's one thing, but to put him in jail and make him wait and interrupt his appointment with his psychiatrist and his medications is really, in my opinion, not rehabilitative and counterproductive for what we want in this community. And he's stable right now and productive and doing well. I mean, really well.
All right. Well, this is the thing. The defendant, again, has committed 2 felony offenses. One involved driving at a speeding through a construction zone while being followed by police officers. At some point, there is a need to protect the public that comes before the defendant's needs. And I'm going to say this, that the jail has an obligation to make sure that the defendant gets the medications that have been prescribed by his psychiatrist. So the idea that somehow the jail is going to deny him those medications, I don't think that's realistic. And there is a nurse over there who makes sure that those medications get administered. And if I have any concerns about whether the defendant is receiving proper medications, I'll get involved myself, and we'll have the jail captain subpoenaed to court here to explain what's going on.
Your Honor, I would tell you that.
No, okay, Mr. Williams, I appreciate that you want to advocate for your client, but this is the time for sentencing. You've had your chance to say what you want to say, and now it's my turn to make a decision. The court must also take into consideration other defendants that come before this court. And I have to explain why this defendant with this type of behavior and this sort of criminal record would be given substantially different treatment than what I would do for any other defendant. So this is what I'm going to do. I guess rather than the community corrections route, I'm going to sentence the defendant to 30 days in jail with credit for the 4 days served. I'm going to hold the other 120 days that's recommended in abeyance to assure that the defendant continues to engage in his treatment with his psychiatrist, engage in the anger management counseling and the relapse prevention program. But there has to be a punitive sanction involved here. The focus is rehabilitation, but when the next person comes in front of me with this kind of record and these offenses, there has to be some explanation of why this defendant would be treated so much differently. And I do think I've given a great deal of leniency in this case based on all of the circumstances anyway, taking into account the defendant's mental health concerns. And so that's it. Anything else for you, Mr. Williams?
No, while the people are present, I just want to inform the court of something that is not related to this case. So nothing more related to this case.
Does that have to do with the victim's impact statement or?
No, it has nothing to do with any of that. It has to do with your comments. There's a young man who I've been assisting. He was just sentenced yesterday in front of Judge Stepka that the jail is refusing to give his medications. Dr. Clark from Munson testified yesterday what was most healthy for him. She's the prescribing doctor, and it's just been a nightmare. So you've revoked his bond, and I just wanted to let you be aware of that because it's just been, I've gotten the ACLU involved. I've notified them. It's just been a mess and a lot of energy, a lot of work.
Okay. Ms. Wilson, was there anything else for you?
Nothing from the people. Thank you, Your Honor.
All right. Mr. Phillips, you need to turn yourself in by 5 p.m. this afternoon. Ms. Odom, did you have
I have that, and I have one question that I need clarification on. So my dispo, this pre-sentence report says one of the charges is attempt, flee, and elude. In our system, they have attempt, flee, elude third, and the probable cause statement says attempt, flee, elude, fourth. I just need to know the difference in what.
It was a flee and elude third that was reduced to an attempt, flee and elude
Thank you.
fourth.
Thank you.
Is that correct, Mr. Williams? That would make it the 1 year.
Yeah, it's the same outcome. It's confusing. It works
Okay,
out.
it can't be a flee and elude third attempt because that would still be a felony.
Thank you, Judge. I'll have him fix it in the system.
All right.
Your
Okay,
Honor?
I think we're all, yeah, go ahead, Mr. Phillips.
I'm sorry to interrupt you. I just wanted to ask and say one thing. I have a letter written from my manager at my place of employment. I don't have to read it if you don't want to hear it. But I do want to say that, like, I told her that I was going through some things and, you know, I might be going to jail tomorrow because my lawyer sent me, you know, the recommendations of the probation officer, and she wrote a very well letter for me, basically saying like she would like to keep me under employment if that was possible. I can read the letter, or if you kind of get the picture. I was just wondering if.
Well, I'm not surprised at all that your employer would want to keep you on. I don't have any indication that you're not a good employee. And given the job market right now, that's not surprising. But you were right to inform her that there may be you may be going to jail today. Hopefully they'll keep that open for you. Employment is obviously important to you also with your recovery. So
Could he have work release, Your Honor, since he has a job? And part of your order was that.
Allow work release if the jail is going to go along with that. But as far as I know, their COVID restrictions are preventing them from doing that right now.
Okay, thank you.
Thank you.
Okay, we're all set for today. Thank you. And I want to thank you again, Ms. Godesack, for providing additional information to the court.
Thank you, Your Honor.
Your Honor, well, if you don't mind, I'd just like to let the court know what's going on. It's Mr. Patson, Cyrus Patson.
Okay, and the prosecutor is here, Ms. Wilson. And so what's going on with Mr. Patson?
So, Your Honor, his bond was revoked. I think you have him on 2 pending domestic assault cases. I resolved his felony cases with Judge Stepka, and he pled to misdemeanors with Holmes Youthful Trainee assignment. He did get 2 new felony charges, cutting his tether off, and I think fleeing and elude on foot by the police when they went to pick him up on the remand from the bond violations. All that being said, he went into treatment prior to all of this. He completed treatment. He got on a treatment plan. Dr. Kelly Clark from Munson I've been providing letters to the prosecutor and the court on these issues. The jail would not give him his Suboxone. They just simply refused to give it to him. We sent some letters from Dr. Clark. They gave it to him one time, and then they thought that he was going to be incarcerated for some long period of time, so they stopped his medication. In fact, they changed his medication. He had blood pressure issues. He got put in isolation when he shouldn't have. Dr. Clark addressed that. They took him out of isolation. And right now, he's ordered to comply with Dr. Clark's medicated treatment plan through Judge Stepka as part of probation yesterday. But because bond has been revoked in his misdemeanor cases with you, they won't release him. Judge Stepka agreed to reduce his bond in his new felony case to a PR bond if you would allow him out on bond, essentially. So Dr. Clark from Munson has been hyperactive in this process. I spoke to her yesterday. I think she even sent a new letter yesterday that I'm going to provide everyone. But he has a treatment plan. And Your Honor, when he got picked up on those bond violations without addressing those violations themselves, which I could if you wanted me to, but when he got picked up on those, you should know he went to Dukoski on his own, went through detox on his own, went through treatment, inpatient treatment on his own, and put himself in a tea house on his own and passed every single drug screens at that tea house, got himself into AA, got himself a sponsor, started working the program, and as Dr. Clark stated, really took all of his medications as prescribed and was doing very, very well and was in a safe place. And she indicated that how he's currently being treated is not safe or healthy, and he's just sitting there. If he were to get a bond on those cases today, he would be on probation with Judge Stepka under Home People Trainee Act as of yesterday. And Dr. Clark is on standby to re-prescribe his medicated treatment plan, put him back on the plan, and work with him for his mental health and his addiction issues. And it's a big problem. I did, like I said, I did contact the ACLU. They found the facts to be compelling regarding the jail and the way that they've handled it. That being said, the disposition in Judge Stepka's case is to continue all treatment with Dr. Clark at Munson and follow all recommendations, including taking all medications. That's an order by the district court that is not being followed by the jail as we sit here and speak today. So that I just want you to be aware of that.
Was the violation in Mr. Patson's case, was it for the felony offenses that Judge Stepka is dealing with?
No.
Why his bond was revoked?
No, Your Honor. The violations were simply he, back in April, before he had posted bond, but before he was released from jail, he sent a very inappropriate and rude kite that was insulting and inappropriate. Mind you, he was going through drug.
Now it's coming back to me.
Yeah, mind you, though, he was going through drug withdrawal and not being medicated properly. Mind you, he was released. That was back in April, and then he did go into treatment thereafter. And then the other violation was a missed UA, but there were many other UAs that were flushed out by Judge Stepka that were done randomly at the tea house that he had passed. So that was an oversight on his part, but that did occur. And then the third one was a no contact violation where he there was contact with the alleged victim in the domestic assault case in a public space. There was a witness that came forward saying that he did not initiate the contact and told her simply he can't talk to her. And then, yesterday there was some mention that he was in violation of his GPS tether, but I never received any information on that. And it was my understanding that he was returning from a meeting with his sponsor at the time of this incident. So nonetheless, I think most importantly, there's an order in place that he needs to follow and take the medication as prescribed by Munson. He can't do that because he's incarcerated. The jail's not going to abide by that order and hasn't given him his medications as prescribed by the Munson doctor. And frankly, he's on probation, Your Honor, with Judge Stepka, and should he be granted a PR bond in the two cases that you have pending, he would be on probation, and Dr. Clark is available through Munson immediately today to resume that treatment plan, and he would go back to the tea house from jail. He would literally go from the jail back to the transitional home where he would have, additional monitoring above and beyond what the average person would have. So all of these measures are in place and there's an order in place. So I just wanted to bring that to the court's attention. I did reach out to Matthias Johnson yesterday. I sent him an email and called him because he's the attorney that the court assigned to Mr. Patson on the issues in front of you, Your Honor. But since that was brought up today, I just wanted to make you aware of that. And it's just been a big concern and a really difficult road we've been on with Mr. Patson and trying to get his medications to him through the jail. I've also notified WellPath of all this. It's just been difficult to say the least. So.
All right. Well, I appreciate the information. I'll take a look at Mr. Patson's various cases. My biggest concern is the violation of the GPS tether that you mentioned, that you're not sure exactly whether he did that or not. But
no,
my thought was release on GPS tether. But if he cut his tether off, we can't very well expect that he's going to do
Your
that.
Honor,
So,
if I could be heard on the bond issue, I didn't
yeah,
realize
go ahead, Mr.
this
Atwood.
was taken up today. I would have appreciated a little notice from Mr.
Well, I think Mr. Williams mainly wanted to share that he's not confident that the jail is providing medications that have been ordered to be allowed by the jail or by the court. And, you know, I have some pretty big concerns about that too. I've got a guy I just sentenced. He's on anti-anxiety and depression medications that, according to his grandma, those seem to be really changing his mood and making things better. And I assured Mr. Williams the jail is going to make sure that he's getting those medications prescribed by a psychiatrist. I can't imagine who would benefit from not giving him those medications. So that's why he brought it up. But go ahead. Before I look at the Patson case, I was going to take a quick look at it after. Well, it's not going to be quick because there's a lot going on there. So go ahead, Mr. Atwood.
Thank you, Your Honor. I just heard a bit of just walking by an office, and I was at the bond motion hearing yesterday for Judge Stepka, and Judge Stepka did not agree to give a PR bond to Mr. Patson if the bonds were addressed in the case before, Your Honor. He said he would take another look at it if a motion was brought. But to say that he agreed to a PR bond is completely untrue. Secondly,
I'm going to object. Please don't accuse me of saying things untrue. I'm pretty sure Judge Stepka said that he would grant a PR bond most likely if he was bonded in these other cases. We could review that transcript, but please don't say I'm saying untrue things on the record.
I would gladly go back and I will get a copy of that.
Thank you.
And Your Honor, Mr. Patson.
Well, there's a difference between he granted a PR bond and he would grant a PR bond if I were to grant PRs on the DV cases.
Thank you.
Correct, Your Honor. So Mr. Patson has had several bond issues since he left treatment at DeCoste. After he left treatment, Ms. Hildebrand made several attempts to get in touch with him about his testing violations. She called, she sent emails. Mr. Patson never responded to any of those attempts to get in contact with him. She was forced to send messages via a GPS device on his tether. He did not respond to those. Then he violated the house arrest condition by going to the location that the victim happened to be at. He knew that she was in that area often because of a family member who had a boat down by the marina. Coincidentally, he comes into contact with her. She calls him out and approaches and says that you're not allowed to be here, you're not allowed to have contact with me. And then after that, we have the issue with the tether, where he had a bench warrant for his arrest, and community corrections sent 3 officers to his the residence at the tea house to place him under arrest for those violations. And they had surrounded the residence, and Ms. Shively arrived there just in time to see the defendant jump out the window after cutting his tether off and running from the officers. And then he was found later on hiding down by Bourbon Lake. The word that Ms. Shively used to me in describing the situation was that he was unsupervisable by community corrections. So they would like to see him where he's at. I don't know what's been conveyed thus far, but the people would strongly object to him being released on GPS tether. Obviously, that hasn't worked in the past. We've had no contact order violations and obviously the new felony offenses for the tether. But I just wanted to be heard on that since it sounded like a bond was being addressed.
Your Honor, since Mr. Atwood has made that record, I'd really like to comment, if I could, briefly on that.
Okay, well, I'll tell you what. I'm gonna cut you off here just because I've got Mr. Kowalski and his attorney here since 9:45 for sentencing, and I really do need to get back to my docket. And I'm sure that you would rebut a lot of what Mr. Atwood has said with something, but
All I was
yeah,
gonna say is,
you know, if you want to file a motion, then that would probably be the best thing, but I will take another look at the case anyhow. And I just want to make one other note that, you know, doctors, they have their primary interest is serving their patient, and that's what it should be and always should be. That they do what's in the best interest of their patient, but the court obviously has other concerns that it has to address, including public safety. And so those don't always mesh what's best for the patient and what's best for the situation. So anyhow, I will take a look at that case. I do appreciate the information provided today, Mr. Williams and Mr. Atwood. And let's go on to our next case then. Mr. Warden, are you ready?
I am, Your Honor.
Okay, so this is People versus Roy Edward Kowalski, and we're here on two different matters. Is Mr. Kowalski present?
No, Your
Before
Honor.
I go too much
Unfortunately,
further.
apparently he's having some technology issues. I did have contact with him in the 9 o'clock hour this morning at the phone number that both the court and I have. He had very spotty coverage. I know he knows of the call-in number and meeting ID. We have reviewed the PSI. I have no explanation why he's not here other than the fact that he was claiming technology issues and his phone and my phone cut out on several occasions this morning. So I hate to say it, but I think at this point, Mr. Kowalski has been communicative. He has reviewed the report with me. Literally, we spoke an hour ago. And I just think wherever he's at, he's having communication issues. So I'm going to have to ask for an adjournment.
Okay, well, if he's been in contact with you, I think that's probably appropriate. I do notice, even though he has, supposedly he's working in Traverse City, I see his residence is St. Helen. Do you know, is he really in St. Helen?
He actually had to move back to St. Helen. That is his father's address.
Okay, well, I'm familiar with that area. My mom lives in Luzerne.
No, that is reflected on the PSI. He's living with his father in the St. Helen area.
Yeah, tell him to drive to Bob Dieter's in Luzerne and he can get good internet connection. Okay, but we will reschedule this and just make sure that he figures out where he's going to get the best connection.
Yes, we'll be prepared. We'll be prepared next time, Your Honor. Thank you.
All right, Ms. Odom, you want to work with Mr.
Sure.
Warden on a date?
Mm-hmm. Do you want to shoot for next week?
Yeah, that'd be fine. The sooner the better on this one.
Yeah. How about Monday, July 12th? Do you think you could make contact with him? And I'm just thinking mailed notice won't make it to him by then, maybe.
No, but I can certainly get a voicemail to him today.
Okay. You want to do that at 9:30?
That's fine with me.
Okay. We'll do it.
Okay, and thank you, Mr. Warden, and we're all set for today on that case. Let's go on to, let's go on to People versus Derek Boyle. Is Mr. Boyle present? Okay, how about Dustin Birch? Well, those are two pleas that we've got set for 10 and 10:15. And it is 10:15 now. We'll give them a few more minutes to appear. And that takes us to our preliminary examinations. So, all right, we'll be in recess until we have something else to do here.
Your Honor, just an FYI, the work release program is still suspended.
So, what's that?
The work release program is still suspended.
It is suspended, okay.
There you go.
I just checked just to make sure. They said, yeah, there's no talk of it firing up again. So,
I figured that's the case.
Yeah.
The,